Lucy versus Zehmer. Court. This case was decided by the Supreme Court of Virginia in 1954. Issue. The primary issue that the court considered was whether a valid and enforceable contract existed between the parties, and the court held yes, it did. Facts. The facts of this case were as follows. The plaintiff, or appellant, Zehmer, and the defendant, or appellee, Lucy, were good friends. One night, while having several drinks together, the two discussed the possibility of Zehmer buying Lucy's farm off of him. Zehmer had proposed the idea many times before, but Lucy had always rejected the idea entirely. On this particular night, Lucy agreed to the sale and wrote up a memorandum on a napkin memorializing the agreement, which included the purchase price of $50,000 and the signatures of both parties. Zehmer then offered Lucy $5 to bind the agreement, assumingly as some form of additional consideration to assure that the deal was for real. However, Lucy rejected the $5 and drunkenly expressed that he was joking about the sale of the farm, a statement that was overheard by a waitress at the bar who ended up serving as a witness. Zehmer immediately went to his brother to secure half of the purchase price, hoping to solidify the deal quickly, considering he had wanted to buy the property for so long. When he brought the money back to Lucy, Lucy reiterated that he was only joking about selling the farm. Lucy was very upset that Zehmer would not honor their agreement, and brought suit seeking to enforce the contract that they had executed on the napkin. Again, the issue here was whether the napkin constituted a valid and enforceable contract between the two parties. The trial court found that it did not, and ruled in favor of Zehmer. Lucy appealed, and the appeals court reversed the trial court's holding, ruling in favor of Lucy. Then Zehmer appealed. Analysis. The Supreme Court of Virginia ultimately held that a valid and enforceable contract did exist between the parties. The court reasoned that the mental assent of both parties was not necessarily required for the formation of a contract. Rather, if the words or actions of one of the parties has only one reasonable meaning, and that meaning is the desire to enter into a contract, the undisclosed intention of that party is immaterial. The court referenced the Restatement of Contracts, which provides that the law judges an agreement exclusively from expressions of intentions which are communicated between the parties. Here, Zehmer admitted that he was not too drunk to enter into a contract, and the court reasoned that joking, when standing alone as a sole defense, is irrelevant, considering that Lucy was unaware of the joke until after the contract was executed. There was an offer on the table, presented by Lucy, and that offer was accepted by Zehmer in a manner which would lead to a reasonable person to believe that he was serious. At that exact moment, a contract was made between the parties, and Lucy is within her rights to call upon the court system to enforce said contract. Because of this, the Supreme Court of Virginia reversed a holding of the lower court and ruled in favor of Lucy. The court awarded him the remedy of specific performance, essentially forcing Zehmer to sell him his farm. Rule to remember. The rule to remember here is that if one party reasonably believes that the other party has the intent to enter into a binding contract and does enter into a binding contract, it is irrelevant to the issue of enforceability that the other party was joking about his intent.